Hello, everyone, and welcome. My name is Matthew Emick. I am the director of the Dr. Charles A. Scontras Center for Labor and Community Education at the University of Southern Maine. I'm very proud to be working together with the City University of New York School of Labor and Urban Studies and the Rutgers University Labor Education Action Research Network to co-sponsor this series of webinars. The National Labor Organizing and the National Labor Relations Board, the impact of recent NLRB decisions. Tonight's webinar is our first of three. Tonight's theme is representation election procedures, fair, efficient, and expeditious with a question mark. And we're very excited to have you all with us. I want to remind everyone, if anyone needs captions or live transcripts, you can access those by clicking the CC Show Captions button on the bottom toolbar. And I want to introduce tonight's moderator, Dr. Rebecca Givan, Associate Professor of Labor Studies at Rutgers University. With that, I'll turn it over to you, Rebecca.
Thank you so much. Thanks to everyone for being here. I'm really excited to get to moderate this panel. I'm excited to learn something, and I think we're really fortunate to hear from our three speakers. I just want to lay out how we're going to proceed. Momentarily, I will introduce Eric Schechter. Eric is from NLRB Region 22. Eric will have an initial section of our panel. We'll hear from Eric, and then we'll have an opportunity for you to answer questions. Eric, as an NLRB employee, will then leave, and then we can say all the stuff that we don't want to ask him to react to one way or the other, and we'll hear from our other panelists at that point, who are both union side folks. So we'll have about half an hour with Eric. First, he'll talk. He'll give a bit of a layout of these new procedures, and we'll have a chance for questions, and then we'll move to a discussion with our other panelists. So. With that said, let me properly introduce Eric. Eric Schechter is the assistant to the regional director of NLRB Region 22, which is in Newark. After earning a master's degree at the Rutgers Labor Education Center, which one of our most we're always proud to see where our esteemed graduates end up. Eric started working in NLRB Region 22 as a career-appointed field examiner in 1989, and he's worked in the region ever since. In July 2007, he was promoted to the position of supervisory examiner. In 2016, he was promoted to his current position as assistant to the regional director. He's responsible for all matters related to the region's overall representation, case handling, processing, and unfair labor practice investigations. He manages the staff and provides assistance to the regional director. So with that said, I will hand us over to Eric. I'll let Eric give a bit of an overview, and then we'll have a chance for questions for Eric. Thank you.
Thank you for that kind and generous introduction, Rebecca. It's nice to be with everyone. And I'm glad we have this opportunity to meet. I would like to share my screen if I have those privileges now. It's saying that I can't. I don't know if that's a problem or not, but maybe we can get that fixed. I'll open with what everybody in the agency and everybody who has access to our guidance memorandums was told by General Counsel Jennifer Abruzzo back on December 8th. Just about 2 weeks before the representation case procedure rule was put into effect. And she wrote that on August 24th, 2023, the board adopted the 2023 election rule, which modifies certain procedures applicable to processing representation cases. Those changes went into effect December 26, 2023. Like the 2014 election rule, which I know many of you are familiar with, General Counsel Abruzzo wrote, certain aspects of which were rescinded by the 2019 election rule. The 2023 election rule removes unnecessary barriers to the fair and expeditious resolution of representation cases. In so doing, the 2023 election rule restores provisions first adopted in 2014. And in that regard, Guidance Memorandum on Representation Case Procedures effective April 14, 2015, GC 1506, provides valuable guidance relevant to the 2023 election rule. Notably, the 2023 election rule will meaningfully reduce the time from petition filing to election and expedite the resolution of any post-election litigation, thereby achieving the goal of fairly efficiently and expeditiously resolving questions concerning representation. Okay, so essentially the rule is attempting to expedite the time from the filing of the petition to the election, the time from the election to resolving post-election issues, and issuance of a certification following an election. How do we do that? What I will do is I will compare and contrast what was done in 2019 under the appointees by President Trump with what's being done in the new rule. In 2019, from the time the petition was filed, the hearing, in case there were any issues that needed to be resolved, was scheduled for the 14th business day from the filing date. That worked out to give or take about somewhere between the 18th and the 20th calendar day. The current rule is returning to the 2014 schedule, which schedules the hearing, if it's necessary, for the 8th calendar day following filing. Under the current rule, requests for hearing postponement, under the 2019 rule, the requests for hearing postponement were at the discretion of the regional director and could be granted without any specific number of days in terms of limitations. The new rule instructs directors that requests for postponement of up to only 2 business days may be granted at the discretion of the regional director, and any additional days would have to be after a showing of extraordinary circumstances, which is not clearly defined, but it's obviously giving the guidance to regional directors that that should only be in the rarest of circumstances. Next change. In 2019, non-petitioning parties must file a statement of position following service of the petition. They must file a statement of position where they would clarify and announce what they are taking issue with in terms of the petition, whether it's the appropriateness of the collective bargaining unit, whether the board has jurisdiction over the employer, whatever the issues were, would have to be raised in the statement of position by the 8th business day. The statement of position would be due by the 8th business day following filing and service of the petition. Thereafter, the petitioner, the party that filed the petition, would have to file a responsive statement of position a few days later, and by no later than 3 business days prior to the scheduled hearing. And any party who doesn't file a statement of position or doesn't raise an issue in a statement of position, who doesn't file a response in the responsive statement of position, may be precluded from litigating issues because of their failure to raise those issues in their statement of position. What happens now in the return to the 2014 schedule is the non-petitioning party. So if the union files a petition seeking an election in an RC case, this would be the employer. The non-petitioning party must file their statement of position by noon on the working day prior to the scheduled hearing. And there is no longer a requirement that the petitioning party has to file and submit a responsive statement of position. Obviously, there's no time now. The statement of position is coming in noon the day before the scheduled hearing. And then the scheduled hearing, at the scheduled hearing, the petitioning party will put on the record what their position is in response to any issues raised in the statement of position that was submitted by the employer, for instance, in a initial organizing drive petition. There's a notice of petition for election that goes out by the region to the parties, and that the employer is required to post and distribute. Under the 2019 rules, that needed to be done by 5 business days from the issuance of the notice of hearing. Now that's reduced, and the posting and distribution electronically, if that's how the employer communicates with its employees, must be done no later than 2 business days from the issuance of the notice of hearing. Again, everything is being compressed with a hope that we can get to an election as soon as possible following the filing of the petition. Regarding issues that may be litigated at a hearing, assuming the parties cannot or are unwilling to enter into an election agreement, and we need to open a record, the 2019 rule essentially returned to a standard that just about any issue that's raised properly can be litigated, regarding the configuration of the bargaining unit, the status of employees as supervisors or as other ineligible employees. The return in the current rule to the 2014 rule clarifies that the purpose of the pre-election hearing is to determine whether a question of representation exists. It limits what we're going to be covered at the hearing. Disputes over the eligibility or inclusion of certain individuals ordinarily do not need to be litigated or resolved prior to an election. Regional directors will have authority to exclude evidence that's not relevant to determining whether there is a question of representation, and thereby avoid unnecessary litigation on issues that can result in substantial waste of resources. So this new rule eliminates the 2019 rule to the extent that the 2019 rule required that individual eligibility and inclusion issues needed to be resolved by the regional director prior to the election. This is the biggest substantive change. Everything I've described up to this point was mostly procedural and administrative, again, with a hope that we would compress the time from the filing of the petition to the conduct of the election. Assuming that an issue of eligibility of a group of employees is comprised of a relatively small percentage of the overall bargaining unit, the regional director, in their discretion, can determine ahead of the hearing that that issue will not be litigated at the hearing, but instead will be deferred, if necessary, to the post-election stage. So, for instance, a unit of 100 employees, the employer says there are 5 supervisors, and I need a determination on their eligibility now. The regional director, in their discretion, can say, you're not entitled to that determination at this time. You can make an offer of proof on the record, but we are going to proceed to the election. We will leave their status undetermined. They will vote subject to challenge. The ballots are not determinative. We will issue a certification that says their eligibility was not determined. They're not included nor excluded. If the union prevails and then the parties at negotiations cannot resolve that issue of eligibility, one of the parties can file a unit clarification petition over whether those individuals should be included. But again, we're not going to litigate it ahead of the election. Where we can avoid it, getting to that election more quickly. Regarding post-hearing briefs, if we do have to open up a record, the 2019 rule says that parties are entitled to file post-hearing briefs and that they should be given 5 business days to file them. They can waive that, but if at least one of the parties would not waive that, we have to give the parties time to file post-hearing briefs. That has been eliminated. There is no such right. The regional director may permit the parties to file a brief on whatever issues are litigated at the hearing, or may limit the brief to less than all of the issues. Maybe the regional director would like briefing on one of the more complicated issues, but not on the less complicated issues. But the bottom line is it's at the discretion of the regional director on whether or not to permit briefs. There's no such right. The expectation, I can tell you, is the default is that we go into a hearing, we open and close these records, we're familiar with these issues. We're usually not going to, absent some compelling reason to the contrary, not going to have a briefing schedule. We will permit the parties an opportunity for oral argument, but again, we're going to open and close that record and then begin the decision writing process at that point. The other change is, this is not much of a change because I think most regions have done this. I know Region 22 has, and it's not any cause for delay, but where it's possible, we should be issuing the notice of election, assuming the hearing results in a decision and direction of election where we are holding an election, as opposed to dismissing the petition. Where we are holding the election, we should issue the decision and direction of election should be accompanied by the notice of election, which the employer is required to post and distribute, informing the voting unit of what's going on and when the election will be conducted and who is eligible and what the payroll period cutoff date is. It can be printed in additional languages if necessary. And that may complicate the ability of the regions to issue it with the decision and direction of election, but ordinarily it should be going out with the decision and direction of election, and it shouldn't be cause for any delay of the election. The 2019 rule did provide for a waiting period between the issuance of the decision and direction of election and the conduct of the election that was actually stayed and never went into effect. Bottom line is, from the time we issue the decision and direction of election now, we should be conducting the election as soon as practicable after that issuance. Now, there are some built-in timelines that we need to comply with. There is a requirement that the employer submit the voting list of employees' names, addresses, available cell phone numbers. They need to electronically submit that within 2 business days from the issuance of the decision and direction of election, or within 2 business days of the approval of the election agreement. That has not changed. The parties entitled to that list, so whatever unions are involved, if there's an individual decertification petitioner, that individual as well, whatever parties are entitled to that list are entitled to have that list for 10 calendar days from when they receive it, from when it's due. Those 10 days can be waived either in part or in full. It would need to be waived by all the parties entitled to it, but assuming it's only one union, and if that union feels like they'd like to have that election and want that 10-day period compressed, we will listen to that request. So the only other item that would, I don't want to say delay, but that we have to figure into the scheduling of the election is the 3-day period for the notice posting that is required under board rules and regulations and cannot be waived and cannot be, even by agreement of the parties, shortened. So that guides us from the time we have an approval of an election agreement or an issuance of a decision and direction of election. We have to be guided by those 2 days that the employer gets to prepare and submit the list, the 10 days that the parties who are entitled to that list are entitled to be in possession of that list between submission and the election. Again, that can be shortened by agreement or by a request of that party or parties. And then we have the 3-day notice posting period. So that's what's guiding us as far as when we can schedule this election. Many of the items, as I talked about, have been compressed. Others, like the notice posting period and the 2-day period for submission of the list and the 10-day period that the union or other parties are entitled to the list, remain in effect. And that's really all I have as far as an outline of the changes that are being that we've returned to since December 26th.
That's fantastic. I want to invite everyone participating. If you have questions, I mentioned up top, we'll take questions for Eric now before we move to our other 2 speakers, and you can submit them in the Q&A, which should appear at the bottom of your Zoom. So please do go ahead and submit. Eric, I know you had a summary chart possibly prepared. Can we share that afterwards with the people that have registered?
Sure. Can I forward it to someone if I can?
We'll figure that out.
Great.
I wanted to start by asking you, this change went into effect in December. In your region, has that now, I don't know if I can say completed because it feels like nothing's ever completed, but has an election now concluded that, or a lot maybe that all took place under these new rules since, I guess, mid-December at this point?
Yeah, we've had in the last, since we didn't have anything in the week between Christmas and New Year's, and then for us at least, the floodgates didn't open. We were a bit surprised that the rate of filing has been flat. Other regions have experienced an uptick. I can't give an explanation for that, but we have had filings. They've so far gone smoothly. We have not had our first pre-election hearing on any of the petitions filed since December 26th. We've gotten election agreements in all of those that proceeded to an election. Several of them, I don't recall the number, it's fewer than 5. I think we've had 10 to a dozen filed since then, and maybe 2 or 3 have been withdrawn, and the others have proceeded to election. A couple of those, I think two of them were withdrawn because the employer agreed to a card check recognition.
Thanks.
So far they've gone smoothly, and even though it's a small sampling, the number of days from filing to the election has come down.
Thanks.
And I could talk more about that in terms of our experience from 2015, if you like.
Yeah, let me take this question from the audience. Sure. What is the status of the blocking charge policy that was included in the 2019 rules? If you could, where that stands, and maybe explain what the policy is for some that might not know.
The board. I just want to get a little bit wonky here. In the 2019 rules, where everything was returned to, litigated if it's raised properly, and cover it, the board around the same time, but not in the same rule, modified the blocking charge policy quite radically, where they essentially said, this is in 2019, that a party to an election, usually a union, that has raised, for instance, has filed unfair labor practice charges that it says it would be unable to run a free and fair election until those are resolved. Prior to 2019, the regional director would consider that and oftentimes would just postpone the election indefinitely. The 2019 rule said that option is no longer available to regional directors in most circumstances. And rather, what was installed was a run and impound procedure where if there was reasonable cause to believe that the ULPs had occurred and could impact the election, the regional director could issue an order proceeding to the election, but ordering that the ballots be impounded and not counted for a period of up to about 60 days following the election. That 60 days, it was expected, would permit time to investigate the ULPs that had some merit enough to at least run and impound. And then if the regional director makes a determination on those ULPs and they are found to have merit, and the regional director then says that meant the election wasn't fair, those ballots could continue to be impounded. Or if a complaint issues, the regional director, and this was a modification by the Biden board under a case called Reith-Riley. They said the regional director still had the authority to dismiss a petition altogether, put the toothpaste back in the tube if an election has already been conducted, if there was merit to the unfair labor practice, and it was substantial enough that a free and fair election couldn't be held, or that the employer's conduct perhaps caused the disaffection, from an incumbent union. And we dismissed a couple of petitions under the case Reith-Riley on that basis. That blocking charge policy, though, that says the only option is to either run and count or run and impound only for a specified period of time, that wasn't changed by, at least not yet, by the 2023 rule changes. We have to wait and see what's going to happen with that.
Thank you.
Yeah.
You want to say a bit more about, you said you offered to say a bit more about the experience of processing petitions since December, maybe really since the new year. Could you tell us a little bit more about that?
Yeah. So going back, I'm just going to, what's old is new. What's new is old. Region 22's experience following the 2014 rule changes, which are the same as the ones that are now reinstated, was that our median from filing to election dropped considerably. And I think that's what we're seeing now since December 26th as well. It dropped, and this includes cases that require a hearing and the election would have been later under the old rules, meaning parties can litigate whatever issues, almost any issue they want. Our median dropped from a little bit under 40 days to around 26 days and change. From filing to the actual conduct of the election. And we were a pretty typical region compared to our sister regions throughout the country. So that trend, I unless something changes, I expect that trend will be reinstated now. What was extraordinary in 2015, I thought, was when I went to the training for these new rules, with again, 2015 rules, the same as what we have now in 2023. The big fear that managers, myself included, was that we would avoid these pre-election hearings, and because we weren't resolving issues of eligibility the way we would in the past, that would create the need to resolve them post-election. And we would have now a huge number of determinative challenge investigations and hearings that needed to be resolved. That doomsday scenario, given our staffing issues, did not materialize after 2015. instead, what happened was we reduced the number of days from filing to the election, and certifications were issued, you know, in due course after that. And we didn't see that great increase that everyone feared in the number of post-election, determinative challenge cases. Just didn't materialize. The finality of the elections, as the board hoped, proved that not resolving those eligibility issues when they arose and when they didn't involve a substantial percentage of the overall unit, when you had those factors, not resolving them before the election didn't result in delay post-election.
Thanks. I think one last question that I have for you, and then we'll let you go, which is that this is from an audience member who says today our union held the first day of negotiations for a newly formed bargaining unit that won an NLRB hearing. The company's appealing the NLRB hearing decision about certain members that were allowed to be in the bargaining unit. The company was protesting the fact that those certain members, the subject of the hearing, should not be allowed to be in the negotiation room. So what rights do unions have to allow those people, in this case disputed bargaining unit members, to be part of the union negotiation team? Is that something you can speak to?
I mean, that's an interesting question, because the expectation is the parties are going to negotiate the ground rules for what can go on in negotiations between themselves and who can and can't be present. And I'm not sure excluding. I'm wondering whether excluding individuals whose eligibility status was questioned and may still be at issue from the actual negotiations could be raised, you know, in an unfair labor practice charge. I think that's a very interesting issue, and if they're letting other members of the bargaining unit in and they're saying these individuals can't be in, I'd like to see an answer on that myself, because I'm not really sure. But I think raising it in the form of an unfair labor practice charge would be the appropriate place. It sounds like their eligibility is still unresolved. So you'll have to see what happens through the negotiations, if the employer yields or if they won't. And then if the union wants them in, you can file a UC petition with the region.
Yeah.
And it'll be resolved that way.
Thank you so much. So I'm going to say thank you to Eric. Eric will leave us, and then we can say stuff that he can't weigh in on. When we were prepping, he was unwilling to be drawn on the pronunciation of Cemex, whether it's Cemex or Cemex. So you'll have to come to the third of these sessions to hear what others have to say about that controversial issue. But
if there's a secret ballot vote, I'd like to be included.
That's good. I want to thank you so much for being and sharing your amazing knowledge and just mastery of these changes that only just went into effect. So I want to thank Eric, and I want to introduce our next two speakers that we're going to hear from. So we have two fantastic folks, both from the Communication Workers of America. With us now, we have Erin Mahoney. Erin's Assistant Director of Organizing. She has over 20 years of organizing experience in a whole range of sectors, including telecom, airlines, higher ed, tech, and games. She started out as a shop steward in her own workplace, became an organizer for the local, then the national, and she's currently based in New York City as Assistant Director for Organizing for CWA. Nick Hanlon is district counsel for Communication Workers of America and has been since 2012. He handles all kinds of labor law issues, especially focused on supporting new organizing. And prior to his role in TWA, he represented various unions as outside counsel, including TWA Local 100 and the New York City District Council of Carpenters. I am going to ask Nick and Erin a few questions to get us started, and then we'll have plenty of time for your questions. You can put them in the Q&A again, and we'll get to as many of them as we can, and we'll try to get into a bit of a back and forth here. So I want to start by asking both Erin and Nick, maybe Erin, you can go first. Under the new rules, what do you think is different from before, from your perspective and the work that you and your members are doing? And what do you think is the same?
Yeah, thank you. I'm really excited to be here. So thanks for the invitation. It was wonderful to hear Eric. So it was a good discussion, very fruitful. I would say, I mean, what's the same and what's different? I think we have wind at our back, and I think that makes a huge difference, especially in this moment that we're in of organizing, where we're getting so many more leads and just so many more people interested in organizing. This rule change in shorter elections, I think, will have an even bigger impact than it did during the Obama period that we had it. I mean, I think it's probably clear to everyone, right? Like a shorter election time means that workers have less of an anti-union campaign. Most workers in this country would, I think the percentage is something is very high at this point. I didn't look it up beforehand, but would want a union in their workplace if it wasn't for in a really terrible anti-union campaigns where they intimidate folks, where they fire our leaders, where they put people through one-on-one meetings and, bribe people. I mean, it's the whole list of things, right? So I think a shorter election means that they have to endure less of that. We had an election that we worked on like right before the rules changed. TCG player in Syracuse, New York, over 300 workers that now eBay bought them, right? Like shortly before the election. And they ran like a brutal anti-union campaign, probably something that I haven't seen since our Cablevision days. I mean, like daily, like hitting these folks with like anti-union misinformation, and fired leaders. They, just really put the pressure on. And because we actually had a shorter election time, they wanted to draw it out with hearings. So things that we were hearing from Eric, right, about the rules change. I don't think we necessarily would have won that election if that had been drawn out for months. So I think this means that we have the opportunity to win more elections and take advantage of worker momentum. I think what's the same is that, we still have to run good campaigns, right? There's no like miracle election rules that means that we win union elections. We still have to push people to be public for the union. That's where our power is in publicly standing together, right? We still have to inoculate on the boss's campaign because we're going to have roughly 26 days of a boss's campaign. I think we have to prepare for the contract fight, which I think that last question kind of was a good hint towards that point. I mean, I've been seeing even where we have kind of neutrality light in some of these elections, like at, let's say, Fordham University, our graduate student workers organized there. We have like a light anti-union campaign, but kind of a brutal contract campaign, right? It's taken over a year to organize there. And if we don't lock in a first contract within the first year, there could be a decertification, right? So we don't really have our union until we have a first contract. So I think it also, shifts our focus to really having a good ground game for that first contract. I think we have to be more prepared going into these elections too. You have to have things quickly. So folks need to be ready, like photos and quotes of people, mission statements, a lot of the prep work that we did somewhat once we went public needs to be done as we're building the organizing committee, just from a ground game tip of some of we have been through some of these elections since the new rules happened, which I can speak to a little bit later, but it's good. I mean, I think the good news is it's wind at our back. I think the stuff that's still there is that we still have to organize a fight and build with workers.
Thanks. Nick?
Thank you so much for having me. The impact, I was just looking, I just saw on a anti-union website, describing the impact of these rules, and it says the impact of the rule is to make it more difficult for the employer to educate the employees about unions and unionization prior to a vote. Now, we would characterize that much differently about what they do in that time period, but it's not. I mean, the impact is very simple. It's less time. for the employer to run its anti-union campaign. And I mean, if you just think about it, it does take time. You know, if you're going to fire somebody, you know, normally they come up, say they want to fire someone because they're a union leader. Normally they, you know, go through their past, you know, their social media posts, their application, all this stuff. It takes time to come up with the, you know, pretext for firing somebody. I mean, and just crafting their objections to the bargaining unit that you've petitioned for, that takes a lot of meetings, a lot of time to come up with some bad faith argument about why these managers should be included, you know, even though they get paid, you know, 100 times more than the members of the unit. So it truncates all that all the time for employer shenanigans, which is great. And they have to, what was the statement of position is now due, you know, the day before the hearing. You know, they've got to commit within 7 days of you giving them the notice of petition, which is normally the first day. It's often the first they've heard about the campaign. Gives you they have to commit to writing, you know, what their arguments be, otherwise they could be precluded. So that just streamlines everything and makes it it gives you a lot more. It not just shortens the time to an election, but it gives you a lot more predictability about when your election is going to be. I think you know, the rules, I've seen people saying the rules potentially could get you an election in 14 to 21 days. I think more realistically, it's going to be, you know, 28 days. But it's going to be in a tighter time frame, so you can plan accordingly. So it's all good.
Thanks. I'm gonna ask a follow-up question to that. It may be more for Erin, it may be for both of you, which is if you're thinking, you know, and I know different unions have different kind of roadmaps to successful organizing, but do you think differently about the quiet phase and the public phase in terms of either going public at a different point, or I think you kind of hinted at, Erin, a few more things in place before you go public? Are there things that you, and I know it's early days, so it may be a little bit of experimenting and going with your gut at this point, but do you think differently about what needs to happen, either what must happen before you go public, or on the other hand, relaxing and saying, you know what, it's going to be so short, it's okay if we don't have XYZ in order, we'll get them done, and there's not as much time for the anti-union campaign, and so we maybe got some different opportunities. I don't know. Do you want to speak to that, Erin, and then Nick, if you want to get into, you should.
Sure. Yeah, I'll say our attorneys are definitely more like, we gotta have this, and this before we let you file. I mean, we're on our game too, but I have a meeting tomorrow with one of our attorneys who's like, we won't file until we have 8 people that are ready for a hearing, like no matter what, like they can't go on spring break, just because the rules are really strict, right? I mean, we try and be on our A game with that anyways, but no, I mean, I think it's a little bit of what we were saying on our end from the organizing perspective. We like to do like a vision statement that we have the entire organizing committee sign on to. We like to have them get people to sign that vision statement when they sign a card, right? So I think we do that the same way. We just maybe need to start getting that started even earlier. Photos and quotes are something that we kind of do as the next activity, and we have a longer time usually to do that before these rules. So I would say in our campaigns, we're starting to get those done before we go above ground, as you said, you know? So I think there's more preparing, you know, I think getting our ducks in a row in terms of like the legal stuff is really important because of the timeline that we're on. You know, I mean, I think I was like, I wouldn't say this publicly. Here I'm on a webinar, no, but I mean, I wouldn't say we should deviate from our model. Like I'm really strict on that with our organizers. We got to like dig deep, but I would say that I probably have a little bit more wiggle room in terms of like the percentages we need assessed as supporters. Like if there was a campaign where I think we have a shot at like, you know, the employer being more neutral or some sort of way to like, you know, have an easier campaign in that round. It's a shorter campaign, so maybe we don't need like the highest percentages that we would go by without these rules. I think it gives us a little bit more wiggle room in terms of strategizing, right? which is good.
Yeah. Nick, you want to get in on that?
Yeah, I mean, I will definitely agree that with this tight time frame, you need to be really ready to go when you file. But as I said, it is much more predictable too. So you can say, it's going to be in 8 days. If we have a hearing, it's going to be in 8 days, and at max, it's going to be postponed 2 days. So in some sense, it's easier to clear everybody's schedule because when things are going to happen, and you can tell them when to expect a decision, when to expect an election with a lot more accuracy.
Yeah. Erin, a point of clarification from one of our attendees. Can you say a little bit more about what the vision statement is?
Oh, sure. Yeah. Well, we built an organizing committee, right? That's going to be the leaders of the organizing drive. Usually if a committee's like, if it's 300 people, we like to have 10%, 30 people on that organizing committee. And then we have that group as part of what they're doing to prepare for starting to sign cards, like write a statement of why they're forming a union, like what some of the issues are, the vision they have for their union, and for things that they want to change in the workplace. And then we have them all sign it. So it's a way to like really train our committee and our leaders to be public from the get-go. And our aim is to kind of come out with a splash. And then as they're getting cards signed, we ask people to sign a union card, but not in secret, sign this vision statement with us. And when we have a majority or significant number, it kind of changes with different campaigns, but a good number on it, we'll make that vision statement public, either in a letter demanding recognition from the boss, or as flyers in the workplace, or in whatever ways we can that kind of put the campaign out there and show our power.
And the vision statement is primarily workers saying why they want to organize together.
Exactly.
Yeah. Question that I was going to ask you, and then I saw Jasmine, Great Minds, hi Jasmine, put in the Q&A as well. Looking ahead, we've got a presidential election this year. We know from the dates that Eric marked of the recent changes that there's a I don't know, flip-flopping, whipsawing, bit of a roller coaster from an organizing perspective as control of the NLRB changes. So what are you thinking about looking ahead, pending the different possible scenarios in the presidential election? I'll go to you first, Nick, and then I'll come to Erin.
So I mean, if Biden doesn't win re-election, these rules should still be in place for some time. I mean, you heard the dates of these rules. Eric kept talking about the 2014 rules. Well, those are the Obama rules. They only came effective 2015. Trump was elected in 2016. These rules, so that took almost 2 full terms. These rules, Biden's been in for 3 years, and they just came into effect now. So they're not going to go out the door on day one. That's because they are the Obama rules. The reason they took so long is they went through the formal rulemaking process under the Administrative Procedure Act, and they got comment from the public, and basically they're harder to change because they were harder to enact, is the way to think about it. And then the Biden board changed, and the Trump board went in and changed the rules without going through that whole process. And that's why many of the Trump board's changes were enjoined by the federal courts. And the current board has now re-implemented these rules, not going through that whole long process, under the argument that they're just rescinding these Trump rules that were not enacted through that same process, and going back for the most part to the Obama rules. So will a federal court, the Republican judge, reject that argument that they didn't have to go through the process just to get that? Maybe so. I haven't looked at it, but either way, it's not going out on day one. So it'll be in place for, I'd say, at least a year or more.
Thanks. Erin?
Yeah, I mean, I would say, I think we might have time afterwards if there's a Trump presidency. I think we're going to have a lot to worry about if there's a Trump presidency. But I think we're in the moment right now. I would say in my 20-year career of organizing, this is the most organizing we've ever done. And we're getting leads in at a rate that I've never seen before. I mean, I actually had our research team kind of go back and look at all of the leads we've gotten since 2020, and we're getting them in at like 3 times more than we did before 2020. So I think, I mean, my point is more just like we're in a moment right now. This rules change is happening right now. We're all in this webinar. We should take advantage of the moment that we're in and organize as much as we can, because I think that's going to help us in the lead up to the election, right? Like it's going to help get folks active in our union and get engaged, and hopefully lead to a better administration being elected. And then we can ride this out for much longer and build an even better and bigger, stronger labor movement. But failing that, we hopefully will have a little bit longer into the next presidency too.
Thanks. I'm going to go to another audience question. This says, when negotiations for a first contract are dragged out by the company, it's frustrating for the newly organized bargaining unit. Unfair labor practice decisions are lengthy, and if the union wins the ULP, the company punishment is only to post the decision about the ULP. Since new bargaining units are not official members until a ratified contract, striking is not an option. We were thinking of holding informational pickets for public awareness. Only 6 people remain from the original 20 employees that started the campaign. Company conditions are less than ideal, and the employees are no longer patient with the negotiation process. So there's a few things there that I wonder if you could weigh in on and say how you see that. I do think I will just editorialize and say that question highlights the problems with a slow timeline and how a delay always works against the workers, right? With only 6 employees from the original 20 leaders left. But Erin, do you want to weigh in on sort of thoughts about a situation like that?
Sure. Yeah, we're having a lot of those. They're really difficult. And I think, you know, our organizers, it's like you go through this, like you're walking through fire and you get this group past the election, and then it's like, oh my God, it's a whole nother thing. And folks are tired, right? And the workers are tired. So I think a couple of things in there. I think we're starting to, as much as we can, you know, we don't want to like dampen like people's excitement, but we want to get people prepared for a long fight. So in the organizing drive, you know, making sure that we're talking about that it's not over at the election. There's gonna be another fight. It might not be you at the, you know, as part of the mobilizing committee, but we need to be developing leaders with that in mind, that there's going to be another fight after the election days. It doesn't end there. We don't get our magical contract. And I think thinking of ULPs in a bit of a different way. I mean, I think, you know, even just thinking, like Eric mentioned, the short staffing at the labor board, right? So we're already seeing it take a really long time to get ULPs, and now elections are going to be the priority. And I think Nick will probably speak more to that. But I think keeping that in mind, that ULPs might take even longer. So in my mind, what I use the ULPs for is, I mean, obviously it'd be great if we can get people's jobs back and back pay. I mean, that's like an amazing remedy to show the union is so powerful. But the other way we use ULPs is just to bring legitimacy to the fight, right? So like elected officials get so much more ready to get involved if there's a ULP. It like legitimizes that this is real. So even you get just a little progress on your ULP, it gives you momentum in your contract campaign to go to friendly electeds. Doing press, like the press takes you more seriously. Like you can do press around even just filing the ULP or any sort of movement you get on your ULP. So just thinking about the ULPs in a different way. And I think in terms of the contract fight and just like 6 people being left, or, you know, the number, we're seeing that too, like drastic turnover in certain shops. You know, treating it like an organizing campaign, staffing it like an organizing campaign, and like being systematic like an organizing campaign. So, so assessing people, right? We have a database leading up to an election because there's an election date and it's serious, but having that throughout your contract campaign too. So having a mobilizing committee that meets once a week or every other week, they're going through their coworkers. They're saying like, who's still supportive, who's wearing a wristband, who's signing this petition, like ways to kind of show support like throughout, and keeping it, you know, keeping your mobilizing committee engaged in that process, I think is really important. And then I think bringing in all aspects of your union, right? So we have several contract campaigns where we have our research, we have a every other week meeting, right? With our research team, our comms team, our political team, our organizing team, and our bargaining team. And like we all get on Zoom or we all meet in person and we go through what's going on at the bargaining table and how we can move other parts of our union to support these workers. And it actually like brings in more parts of our union than our organizing drives do oftentimes. So they can be good ways for folks to kind of understand each other's work and build the power of your union behind this really tough fight.
Thanks. Nick?
Yeah, Erin, you left out our legal team. We're also on
Sorry, yeah, you're in all of them too, Nick, but you're right here
It's-
with me. So
So I mean the first contract campaigns, as the question indicated, are really, really tough, and we are also experiencing a lot of really tough ones now. I will respond to two of the things that in the question said. One is that the strikes aren't an option because people aren't members yet. That's not exactly the case. I mean, strikes are an option. I'm wondering if my screen froze. I don't know if everyone heard my sound. They're not always advisable, especially if you've had high turnover and people are worn down. It might not be an option for that reason. And ULPs. I think the question said, if I heard it right, that the only consequence is a notice posting. But that depends on the ULP. Many ULPs, you can get people's jobs back. You can get, if terms and conditions of employment have been changed unilaterally, you can get some, sometimes financial remuneration for people if they lost out economically due to the changes, which is a great morale boost. But the bigger problem with the ULPs is what Erin mentioned. They are taking forever now. And what Erin alluded to with these new rules is there's so much, the board has so little discretion now in fast tracking these representation petitions that's going to mean they're going to have to prioritize that over investigating and litigating ULPs. So we might see them get even slower now. They're slow because they're slower than ever now because the board is understaffed, underfunded, and there's more interest in unionization and more ULP and in our case activity than ever before, with less staff to deal with it. And also because the current general counsel has expanded the definition of an unfair labor practice in a number of areas. That's my theory, and I think they're probably being inundated with all these ULPs that around conduct that weren't previously considered unfair labor practices. So with that said, you can't file a ULP and think that's going to solve your problem, get you to a contract, because it's going to take a long time to resolve. There has to be organizing around it, media around it, politics around it, and then hopefully before your certification year is up, maybe you have a settlement or an award that boosts morale and helps out and shows the power of the union to everyone at a critical time.
Thanks. Erin, I'm gonna come back to something you said before and ask you, and I'll ask you to sort of lead us off, but Nick can also round out some of the legal pieces, sort of walking us through a campaign. You can obfuscate if it's something that hasn't gone public yet, or you can pick something that has, where you're thinking about it specifically in terms of the new election rules and how how you strategize and how you implement your plan with that. So if you could just kind of take us through that.
yeah, how can I kind of think through one that's building but maybe hasn't gone public yet? I think it's a little bit of what I said earlier, right? Like we're still building in the same ways, but it does help us make more strategic decisions for folks that are a little bit on the line. So I think, we build an organizing committee, we get a lead come in, or, we're strategically looking at places that would help build power for our union, and we find a lead. From there, we work with those people to build out an organizing committee. Like I said, we like to have a 10% organizing committee. And sometimes if that unit is really big, that takes a little bit longer, or if they're not really working between departments, there's not a lot of interchange to talk to each other, know each other. It takes a while. And then what we'd like to do is go through and assess the support, even if it's just a guess assessment, right? Of like, I think, hey, I know Nick, I think he'd be supportive. He's a labor lawyer, right? and we make we track that. And so I think, you know, where there's a couple of campaigns I can think of right now where we have the sense that like if these folks were following their mission, or you know, if they were they would then they would potentially not run an anti-union campaign or not push back as hard as some of the others that I've talked about. And maybe we aren't necessarily at 70% support, which is where I would like to be if we're going to start dropping cards. So I would like to have assessments of the whole unit. I'd like to look at the organizing committee and say, our organizing committee can reach 100% of the unit. There's not like a group of 20 people that are unassessed. That means to me that people don't know them. So I think that's kind of where the strategic decisions are a little bit. It falls between like, do we have any reason to believe from our research or our political department that this employer might not give us a fight in the same way, or might not fight, you know, the union's democratic right to form a union in the same way as other really brutal employers? And then can we adjust a little bit in terms of our percentage? Could we maybe start dropping cards at 60%? Could we drop cards if we don't necessarily know? Could we go public with not knowing a department or two, right? And then find the department when we go public because we know the election is going to be shorter. So I think and then once we have an election, right, we do have some wiggle room. I mean, I'm saying like it's hard to get a first contract, and that's true, but you're walking through fire, and you're through the first fire, right? And you've got a year to like build there. So we have to have a plan to win. But I think there's more room to like build the plan for the contract campaign once we win the election. So having a shorter election, I think, gives us more wiggle room in terms of like the assessment of support. And there are several units that we're looking at that way, where we maybe we move when we wouldn't move before, or maybe we have like a leap in terms of the coverage that we have, that we think we can go public and find that coverage, if that makes sense.
Yeah, one quick question just to explain something a little more. Somebody asked about photos and quotes. I know those are one of the probably essential aspects of pretty much all organizing drives. Can you say a little more about what that is and why it's an important benchmark, I think, as well as a organizing tool?
Sure, yeah. I mean, it's similar to the vision statement. What we have is like folks take a photo, or, you know, as we're doing a one-on-one, we do a photo with them. And they give a quote as to why they're forming the union. And then I wish I had a couple to show you, but they're beautiful. Then we make them into a big poster that like we can mail to folks, or people can use in the workplace, that has like 100 photos and quotes of why people want the union. And it just shows our breadth and strength, and shows that the union is the workers, right? It's your coworkers in your workplace, your friends, you know, it's not like some outside third party that lives in New York or DC or something. It's people right here in my community that I work with that are doing this. And it gives people more courage to step up themselves, and makes people feel like they're a part of it, and that they can affect like where it's going and what it's about. And it takes a lot of wind out of the sails of the anti-union campaign, because the whole anti-union campaign is based on fear that the union is going to come in and control your life. And when people are like, oh no, it's me, it's my friend Nick here, you know, then it's a much different energy and excitement.
And I've certainly seen CWA drives go public where like not only there are a large number in support, but like 80-90% of workers have a photo and quote, even fully public, and some really impressive work.
Totally. It's a way to find out how far your support is too, right? Like as an organizer, to know that like, okay, these people are really with us because they're out here with their photo and their quote publicly.
Yeah, Nick.
If you have 80-90% of the people with their photo up, it also, I think it makes the employer back down from their most aggressive stance.
Yeah. You want to say any more about the way you think about kind of what Erin laid out, Nick, if you want to add anything?
The one thing I just wanted to revisit was, Eric said that he hadn't, his region hadn't yet gotten to a pre-election hearing since the new rules went into place December 26th, and that's pretty consistent with our experience back during the Obama rules. That one effect of these rules, I think, was that employers would be more likely to agree to an election, to stipulate to an election. And And what they would do, their tactic would be they would try to raise some kind of issue about the appropriateness of the unit. Maybe it was an outlandish issue saying, oh, there's thousands other people on the West Coast who should be included or something like that. Some kind of issue that raised the challenge of the unit in a big enough way that they could get a hearing even under the new rules. And they didn't really intend to make that fight. They were just trying to threaten to delay it as long as they could, and saying you might as well just agree to an election date that is as late as we could stretch this out through these bad faith arguments. And your option there usually was just to agree to that date, and that's what 28 or slightly more days came from, and that's what I think we can expect to see a lot again.
Yeah. This is very, very speculative, but do you, either of you, anticipate more employers agreeing to card check voluntary recognition because of the speed of the election? Just, if they see the writings on the wall, or I don't know how you're imagining that. I know it's really asking you to speculate.
I think it's interesting. I mean, I don't know that they would agree to card check more. But I do think I was going to make the point that I think it's, with the new election rules and shorter timeline, I think there's a lot of wind at our sail, a lot of wind at our back, or whatever the phrase is. But I think what you were kind of hinting at is card check and neutrality, where the employer agrees to recognize the unit if a majority of the unit signs union cards, is kind of where we get the big numbers of folks organizing and a lot of power. I think it is hard to win these on election. I think the expedited will help us, but just for an example, Activision Blizzard is a video game company, right? That we organized footholds with the election. And so we were able to organize 28 workers in Wisconsin at Activision Blizzard and 22 workers in Albany, New York. Those are small units, but it gave us a foothold, and we're at the bargaining table, and it created momentum and interest across a 5,000 person unit, right? 5,000 people across the country work for Activision Blizzard. And then we using other parts of our union, we were able to take advantage of different things that happened, right? Like Microsoft is buying Activision, and we're saying that merger should not go through unless workers have a voice and a seat at the table. And we made that very clear. And so, other factors where we got different parts of our union together to push that. And Microsoft decided we're going to be the grownups in the room. We're going to agree to neutrality and card check, and have been a good partner, actually. And we've got a card check agreement for 5,000 workers. And I think we're set to win, several units of 500 and 400 and 300 soon. So it's exciting. And that's where we're winning in a bigger way. So I think that the shorter election time and the NLRB can be footholds into bigger industries, that if we're using all arms of our union and our movement, that then we can use those to pressure card check agreements. But that getting a quick election and getting in there with some of these units, I think, can be benefited from having these shorter election rules, if that's kind of a circular way to get to it. But
yeah, Nick.
Yeah, I mean, we've done a lot of card check in the past few years, but it's really been because we've just been organizing in spaces with employers where that's easier to push that on them, academic, not-for-profit, things like that. People that can be shamed or pressured into doing the right thing. One issue there is that you don't encounter as much if you, especially with the new election rules, if you were to file for a petition, is, when you're negotiating the terms just for an individual card check agreement like this, not like the type of thing that Erin referenced with Microsoft, but, if just a card check for a specific campaign, you go in and you negotiate card check, perhaps neutrality, but you're also going to negotiate the contours of the unit, and that can slow things down, and sometimes it's frustrating, and you think, well, we could have just gone to the board and gotten these people through the legal process at this point, and now we feel like we have to horse trade on this little department or this here to get card check. Overall, it's a good thing, but sometimes you feel like you might be better off just going with a petition and with these rules, then you feel even more confident that you could get what you wanted that way.
Yeah, I want to ask you a little bit more about I think it's important that we have talked about the fact that unfair labor practices we expect to take even longer than they have been. Before I ask this, I want to remind folks, we have about 15 minutes left, so we have time for more questions if people want to put them in the Q&A. But in terms of unfair labor practices, I think it's important that Erin pointed out that they're not usually the answer, although you can sometimes win materially important things through them. They're one tool of many that you use. But I wonder if, given what we expect with the timeline of unfair labor practices, do you see any motivation to try to negotiate resolutions and just not even file as many unfair labor practices, or just assume that even if you do file, that's just symbolic because it could be a year or two and that doesn't really help you, for example, win this contract that you want right now? Do you see a sort of a different approach or a different role for ULPs, given that I think the reality is, unless we get significantly more NLRB funding, they're going to just even slow down even more than they have?
I mean, I don't, I certainly feel in this environment that I'm much more cautious about the quality of the ULPs that we file, but I would favor, if you have a good one, file it. You may be able to resolve it, without the board involved, one way or the other. If you've gotten often if your ULPs are unresolved and you're towards the end of a contract campaign, you can, get the last couple of things you want at the table and withdraw the ULPs. So, that's there, even if they're just sitting there on a board agent's desk who doesn't have time to look at them. So I wouldn't say not to file, but I do think all the ULPs we're filing now should be pretty solid.
Yeah, I mean, I think, yeah, and I think it's similar to what we were talking about earlier, that like using them in a strategic way to bring legitimacy to your campaign and to bring pressure in different ways and bring more people into your contract campaign or your organizing drive. I think for the first contract too, in addition to like having them, if they're good ULPs, having them on the table, if they take a long time to get there, right? If you have an active ULP, then you, potentially like don't have a decertification, right? Like it might prolong your ability to stay at the bargaining table and push the employer to do right by the workers. So that's another thing. But I think being careful, I agree with Nick, like not to do frivolous ULPs that we're not going to win and put workers' faith in them too much. And then there's even more disappointment when they're dismissed or we don't win them. So
yeah, and on the strategic side of filing them, it's a lot easier to get a politician to make a statement, to say something on social media if the allegations at least sound bad. If they, if it's just, I mean, I guess you could make a captive audience meeting sound bad, but it doesn't sound as bad as a termination or taking away people's health care or something that people really sympathize with, and it's that's the other sense in which they could be a stronger or weaker ULPs.
Yeah, I'm gonna step a little outside of the parameters of this session and into sort of the sort of starting to think ahead to what we're going to hear about in the next couple of weeks, which is bargaining orders and CEMEX and joint employer possible rulings. How or do you see the quicker elections fitting into those other changes that again are just kind of rolling out now, and we're just going to see what the impact is? Are there strategic pieces that touch on all of those? Do they change anything? Or and feel free to answer, let's stick to nuts and bolts organizing. All of these are not the most significant factors, but how do you see the election changes fitting in with the other changes as you're thinking about organizing and to some extent bargaining strategy?
I mean, I'll take it maybe at a bigger view, and then Nick can go into the more the nuts and bolts. But I mean, to me, it's like they all kind of knit together in just like unions and workers having more power, right? Like if we connect all of these dots, like we should take that and kind of and run with it in a bigger way. So you know, I mean, even things like just, you know, making a captive audience meeting a ULP. Like there are ways around it, the employer gets around it, but the fact that we can tell workers like, you know, this is illegal, you know, we can file an unfair labor practice if this meeting is mandatory. It gives like workers a sense of empowerment from that. And the fact that we've got a labor board and an administration that is standing with labor, I think like puts employers on the defense, and in whatever way we can take that momentum and run with it, I think is important. And I think having some of these decisions forces, like if we're in a neutrality agreement and trying to like think of the terms of the neutrality agreement or implementing a neutrality agreement with some of our friendlier employers, they have to think of CMIX and like, what are the implications of this if I know that I have majority and I'm not recognizing the unit, or, you know, it gives us some more room to think through things with both friendly employers and then the really antagonistic employers. I think it does put them on their heels a little bit more. So I think together they're not insignificant.
Yeah, just think about how CEMEX will interact with these new rules. I mean, they're kind of just very different things. You know, CEMEX seemed like, you know, when I remember when it first came out and first read it, it seemed quite radical. But, you know, as we've, you know, thought about it through more deliberately, there haven't been a lot of cases where we're decided to follow the procedures of CEMEX. So, I mean, for, you know, I think people may know, but the basic thing there is if you demand recognition, CEMEX now puts the ball in the employer's court within 2 weeks to either recognize you or file for an election themselves. So, I mean, of course, so that's a little different from. I mean, the one thing of the employer bar calls these quicker elections ambush elections, and sometimes they are done like that. Sometimes you don't go public until the day you file the petition, and you're going to use the speed of that to your advantage. In cases where you do, you know, demand recognition, go public before you file, you know, now CEMEX is going to get the clock ticking on the employer to file a petition. I think again, there's not a lot of situations where we've wanted to do that and haven't wanted to just control the timeline, file, and kick off the process ourselves. But as Erin said, it does kind of put the employer on its heels. If you demand recognition and their lawyer tells them the next day, probably, you know, you've got to either recognize them or file something within 2 weeks. It's just one more thing to put them on defensive and to hopefully use to your advantage.
And I think we like to keep the CEMEX or CMEX decision kind of in our back pocket too, as we're filing, right? Like we do it all, we cross our T's and dot our I's, and then, you know, to play it out. Like if the employer runs an anti-union campaign that's so terrible that we lose the election, like we've crossed all our T's and dotted our I's to say, hey, maybe there should be a bargaining order issued here, and you have to just bargain with this group because you tainted the election so badly. I mean, I think we don't go into that as our strategy, and we haven't in terms of like that, we're aiming to like lose the election. But there are problems to think through that too, that I don't know that we've realized of like, how do you then, you know, organize that group, you know, of like half anti-union people. You gotta have a real strategy there of winning folks over and building a cohesive unit at the table. So I think there are kinks to still work out with that strategy, which will be interesting for the next session that you guys do on it.
And it, just to reiterate, it may be more, its ultimate effect may be more to discourage
Right.
winning ULPs in the first place than to actually use the precedent set by that.
Yeah. I want to ask you, this might be a question for Erin, who presumably receives a lot of the organizing leads, but I'm wondering, I think about whether, you know, telling workers honestly that they can realistically expect a quicker election will encourage some different kinds of workers to organize. What I have on my mind, I work in higher ed, and we have, you know, grad workers and postdocs who are in the jobs for a short amount of time. I know the hot thing now is undergrad worker organizing, right? A lot of RAs and undergrad dining hall workers are organizing, medical interns and residents are organizing like crazy. I think their Maine union is on course to double membership since the start of the pandemic. So is there something that there, I mean, I know we're always going to return to, it's not a recipe for any kind of shortcuts, but in being able to think through with workers who don't expect to be in that job forever, not just because it's a high turnover job, but it's really a fixed term position, that this might create an opportunity for those categories of workers?
Definitely. Yeah, no, definitely. I mean, like I said, we organized Fordham University graduate student workers, I want to say a year ago, it might have been longer at this point. But I mean, that was definitely in our minds, right? Of like, you have to get the organizing committee up and running, you have to get a majority on cards, and then you have to get an election pretty much all within one semester, unless you start in the fall with the hope that you're going to do it second semester. Otherwise, you lose a big portion of those folks that vote over the summer. So I think that'll be huge. I mean, I think one of the units I was talking about earlier that not naming was 1,000-person unit in higher education, right? Like that we need fast elections in order to move that. Otherwise, it's going to be that much more difficult. So 100%. I think there's also interesting just thinking through like what other units could be affected by smaller elections. I mean, branch workers. So we've actually filed for Wells Fargo workers, like 4 units. Like we've had a bank campaign going for years, and we've got some momentum among Wells Fargo workers, and I want to say, yeah, 4 branches have filed in one since the new rules happened. And I think there's kind of a domino effect. When you win one, then you've got another, and then you've got another coming, and it creates like excitement and momentum and like the possibility that you can win, right? And so that triggers more people moving. If each election takes 6 months, like you don't have as much momentum coming off of each small unit. So I think thinking that for different groups and different types of workforces is interesting and important.
I'm going to go to, I think, one last question, which is, have you used the presumption of being the representative after demanding recognition under CEMEX to gain workplace access, represent workers in discipline, et cetera, before the election happens? Do you have experience of that yet?
I do not.
Okay. Erin?
I don't either, but it's definitely something we've been throwing around. You know, I think like everybody, like the whole philosophy is like, let's act like a union. Like we don't need an election even to be a union. And I think this brings it to a whole nother level and gives us some more opportunities to be really creative with that. So we've definitely been thinking about where we could use it.
And we'll have a whole session focused on CEMEX in 2 weeks. So that'll be a good one to bring up again. I think on that note, I want to thank Erin and Nick. This has been really tremendously informative, and it's great to hear both your wealth of experience and also your speculation about what's to come. So I really appreciate you guys taking the time tonight. I know how busy you are with all the inundation of organizing leads, which is very, very exciting, and we're looking forward to hearing about lots of quickie election or ambush elections, CWA wins in the coming months. I'm gonna thank you guys, and I'm gonna turn us back to Matt, who will bring us home, and we'll get a preview of the next couple sessions.
Yes, thanks again, Erin and Nick, and thank you, Becky, for a great job moderating, and to all in the audience. Thank you. We're excited to have you here. And as we said at the beginning, we have 2 more webinars after this one. And to talk about our next one, I'm now going to turn things over to Sarah Watson, the director of the City University of New York School of Labor and Urban Studies.
Thanks, Matt. And thank you to all of our speakers tonight. I'm Sarah Watson. I'm the director of the Murphy Institute at CUNY School of Labor and Urban Studies. And we're really appreciative of the program tonight and excited about next week's program. So Thursday, February 22nd, again from 7 to 8:30 p.m., session 2, Making Big Bosses Bargain, the new joint employer rule. And we're thrilled to have Millie Silva, Secretary Treasurer of 1199 SEIU, United Healthcare Workers East, and Ellen Ditchner, Distinguished Lecturer, CUNY School of Labor and Urban Studies, and former chief counsel to the chair of the NLRB under President Obama. And next week's program will be moderated by Cameron Black, who's an assistant professor at CUNY School of Labor and Urban Studies. So we encourage you to stay tuned and join us again next week, and then again on the 29th for the last session in this program. Thank you to everyone who joined us tonight on Zoom. We appreciate you spending your Thursday evening with us.